Order. The clerk will now proceed to read the orders of the day.
Item 1, Protection from Harassment Amendment Bill, second reading.
Minister for Law.
Mr. Speaker, on behalf of the Minister for Law, I beg to move that the bill be now read a second time. Sir Tim Berners-Lee introduced us to the World Wide Web in 1989. 30 years later, more than half of the global population, 4.4 billion, are active Internet users, 3.5 billion of which are on social media. The ubiquity of technology, the way it is embedded in every aspect of our everyday lives, is a given. It has gone beyond just being a useful tool to help us perform tasks, to becoming the primary means by which we search for information, we communicate, and we socialize. It is commonplace to see families, groups of friends, all sitting around a table, looking down at their phones. Some figures to demonstrate the widespread use of the Internet and social media are as follows. Google handles more than 5.5 billion searches each day. 2.27 billion monthly active users of Facebook. There are 500 million tweets which are sent each day on Twitter. And almost 5 billion videos are watched on YouTube every day. Singaporeans are at the vanguard of growth in Internet use. In 2017, Singapore, alongside Sweden, topped the Global Inclusive Internet Index. This index measures the adoption and ease of access to the Internet. There is no question about the benefits of the Internet and social media and the convenience that they bring to our lives. But these benefits also come with a price. In exchange for this convenience, we have in turn bestowed significant power on the social media companies. We voluntarily surrender personal data to them, exposing the most intimate details of our lives on social media websites. We are often unaware that websites and companies are collecting and amassing our data without our knowledge until perhaps a scandal breaks. Last December, Facebook admitted that it struck deals with companies like Netflix, Spotify, that allowed them to read, write, and delete private messages of users. Google+, for instance, on 2 separate occasions last year, admitted that it had exposed personal data of over 50 million users in total to third-party developers. After the first discovery, that mistake was hidden from the public for over half a year. Amazon's Alexa, as another example, an always-on device in our homes. Bloomberg recently revealed that the team charged with auditing commands given to Alexa had access to customers' home addresses and other personal information. Alexa also recorded private conversation and sent it to users' acquaintance. In short, there is no adequate way to moderate and control how this information is used or shared by others. And it is not a simple matter of a leak of data or loss of privacy. Many of us think that we still have some measure of control over our privacy. Some brush off loss of privacy, saying it is a worthwhile exchange for the convenience and benefits technology brings to us. But we fail to recognize that the digital traces that we leave online can be connected and thereafter shared with others. There are wide-reaching and sometimes devastating repercussions that could occur. There are some key areas of concern for us, and I'll enumerate them. First, on cyberbullying. Cyberbullying is really traditional playground bullying transmuted into an online new digital form. In many ways, it is more insidious than traditional bullying. There's anonymity, there's a lack of physical confrontation, and it allows people to engage in conduct that they may not ordinarily engage in normal daily life. The effects are more wide-ranging, more long-lasting. The abusive comments that are put up can be permanently displayed on the Internet. They are broadcast to a large online community, and in truth, the victim has nowhere to hide. In our 2014 second reading speech on this bill, POHA, the government highlighted alarming trends about cyberbullying. Since then, matters have grown worse, and I'll cite a few numbers to this House. In 2017, a survey commissioned by Talking Point found that 3 out of 4 children and teenagers have reported being victims of cyberbullying. In a 2019 Google survey, teachers in Singapore viewed the need to prevent cyberbullying as the most pressing concern when it comes to teaching children about online safety. Consequences of cyberbullying can be dire. The Journal of Medical Internet Research published a study last year and showed that cyberbullying raised the risk of self-harm or suicidal behavior amongst young persons by 2.3 times. The latest research suggests that bullying may cause physical changes in the brain, increasing the risk of mental illness. Studies have also shown that bullying in childhood has effects that last into adulthood as well. Mental problems include anxiety, depression, suicidal tendencies, poor general health, lower educational, financial, and social functioning. Many suffer in silence, and we may not know till it is too late. In Singapore, for instance, reported a few years ago, a 13-year-old girl was bullied by her friends on Facebook and in a WhatsApp group. She started cutting herself with metal rulers and razor blades as a result, causing injury to herself. In the US, a 12-year-old girl in Florida hung herself after being subject to cyberbullying by two 12-year-olds, rumors about having sexually transmitted diseases, vulgar name-calling, and the like. In the UK, a 17-year-old boy in Manchester stepped in front of a train after he was called, and I quote, a black rat and ugly online, both by people he knew and also by people who were complete strangers to him. The second area of concern is in doxing. Doxing is the disclosure of personal information to cause violence or harassment to others. The term was originally used in the 1990s to describe a tactic used by hackers. They would release dossiers of personal information about other hackers to breach their anonymity and expose them to harassment. We are familiar with some local examples. The Caltex incident, members would know, about the couple who pushed the old man at the Toa Payoh hawker center, and of course the Anton Casey case, where he had to leave Singapore as a result. Some may say these people get what they deserve. But doxing has a darker side. It has been used as a political tool by extremists. In the US, an ISIS-linked group published names, addresses, and phone numbers of 1,400 mostly US military and government personnel, urging supporters to attack them. Can you imagine if you were one of these 1,400? In New Zealand, in the wake of the Christchurch terror attacks, as an anti-gun control Facebook group posted contact details of the Queenstown detective online. One post featured an image of a rifle and words, quote, "Come and take it." You can imagine how dangerous this information is and can be in the hands of wrong people. Some other examples. In New York, an 18-year-old gifted violinist. He killed himself after his roommate live-streamed him behaving intimately with another man to 150 people. Also in New York, a journalist, Asher Wolf, he made anti-war posts online. The address was shared on the dark web, and people posted dog feces through to her in her mailbox. In South Africa, a journalist, Karima Brown, her contact details published on Twitter by the leader of the Economic Freedom Fighters, received onslaught of graphic messages threatening rape and murder. Some threatened to expose her flesh by peeling her skin off. Finally, in Boston, there was a misidentification of a Boston bomber. After the Boston Marathon bombings, online citizens on Reddit wrongly identified Sunil Tripathi as the Boston bomber. The family received hundreds of threatening and anti-Islamic messages, even though they are not Muslim. Third, area of falsehoods. Falsehoods are disseminated even more easily today for a number of reasons. First, the psychology of Internet users. Internet users are prone to confirmation bias. They have shorter attention spans. People skim rather than critically evaluate content. They tend to share information because it triggers an emotional response, more so than because of its credibility. Users generally share links without even having read them. And when content gets shared enough times, they seem and appear more credible. There's also a market for online disinformation tools and services. Fake social media accounts commonly used to spread falsehoods. Click farms consisting of large number of low-paid workers can be used to sell video views, likes, and even votes. For instance, members will probably know that 1 million Instagram likes can be bought for US $18 and 500 retweets for US $2. Bots can sometimes take the place of these low-cost workers as well, enhancing the spread of this online disinformation. Other online influencers can also be paid to spread false content, and clickbaits can be used to profit from internet traffic. Falsehoods affect people in real lives, as well as entities. Some examples: it affects those close to home. One of our local actresses' message was circulated suggesting that she had an STD. She started receiving messages such as, "Are you a prostitute?" and "Heard you have STD, get well soon." Lewd comments continued to surface even after the facts were put out, and it affected her reputation even as she tried to venture overseas. Recently, the Select Committee on Online Falsehoods heard from a new citizen, Mr. Hitamas Sarya, falsely identified in an article as a new citizen who was disappointed with Singapore and considering giving up his citizenship. The article was shared over 44,000 times on Facebook. The family was deeply affected by numerous xenophobic comments made about them. Just last week, fake news on Facebook that a veteran of our local acting scene, Lim Kay Tong, received a 16-year sentence. In truth, this was a clickbait. When users clicked on the link, it led to a recipe for tikka. Another linked to a recipe for pumpkin spice cheesecake. But the impact of the clickbait was self-evident. There's also fake news circulating on WhatsApp that Fandi Ahmad had been taken into custody for hurting someone. Again, a clickbait. Falsehoods about companies can cause them irreversible damage, set off a public relations nightmare, and cause economic damage. Even giants like Coca-Cola are not immune. There have been stories claiming that parasite worms were found in bottles of Dasani across the country, clear parasite worms. Several hundred people have been sent to hospital as a result. That FDA had shut down a manufacturing plant. Coca-Cola, of course, denied this, as did FDA. NTUC Fair Price, closer to home, affected by multiple rumors. In 2007, a photo suggesting that NTUC sold halal pork circulated on the internet. Similar rumors later affected Ya Kun Toast and a Yong Tau Fu business at Westgate Shopping Mall. In 2017, members will recall that there were posts going around social media suggesting that Fair Price house brand was made of plastic. All untrue. Studies paint a bleak picture of a world where the spread of falsehoods over social media is quick, wide, pervasive, whilst truth, even if it corrects the original falsehood, lags far behind. In an MIT study, the study analyzed 126,000 rumors that spread on Twitter over 12 years. The study showed that rumors travel faster, farther, deeper, and more broadly than truth in all categories of information. A study showed that tweets which perpetrated a falsehood about Ebola virus being transmitted by air outnumbered tweeted corrections by 2.7 to 1. Another study by the Journal of Experimental Psychology indicated that repeated exposure to a false statement on social media made it more believable. And finally, a University of Buffalo study, 20,000 tweets during Hurricane Sandy and the Boston Marathon bombing showed that 86 to 91% of active Twitter users spread falsehoods. Nearly as many did nothing to correct that. It is self-evident, partly from what I've seen and partly I'm sure from members' own experience, that the internet is almost impossible to control, akin to a lawless jungle. As in any jungle, the weakest and most vulnerable are disproportionately affected. Recent surveys show multiracial females have the highest risk of being harassed online. Adolescent girls are more likely to experience cyberbullying than boys. 75% of children with autism are bullied online. 70% of children with physical defects are bullied online. LGBT teens are 5 times more at risk of being abused on Facebook than non-LGBT teens. This online harassment translates into real-world violence. 1 in 3 women in the US experience domestic violence, and nearly 90% of domestic abuse shelters and programs report that abusers have intimidated and made threats against them using electronic means. An Australian survey found that 98% of domestic violence practitioners reported clients who experienced technology-facilitated abuse. We cannot trust the internet companies to regulate this jungle. Why? because their primary motivation is the pursuit of profit. An internal company memo by Facebook Vice President, Mr. Andrew Bosworth, in June 2016, he claimed that any growth on Facebook was good. And let me quote the memo. He said, "Maybe it costs a life by exposing someone to bullies. Maybe someone dies in a terrorist attack coordinated on our tools. And still, we connect people. The ugly truth is that we believe in connecting people so deeply that anything that allows us to connect more people more often is de facto good," unquote. This memo was leaked 2 weeks after the Cambridge Analytica scandal broke. There is not enough transparency in how administrative standards are derived and enforced. There's no democratic process and no court process. Facebook only made public its community standards in 2018 after Cambridge Analytica scandal erupted, 14 years after Facebook was first founded. People have no faith in social media giants to contain harassment. Users have complained that social media companies have taken days to address the complaints about harassment, if at all. A poll in the UK this year showed more than half the reports that women lodge about harassment on Facebook are met with either no response or a response that the behavior did not breach their own community guidelines. A Singaporean girl saw a minister to complain that she had a picture put up on Facebook by a male acquaintance along with derogatory remarks containing sexual innuendo. She wrote to Facebook, whose response was that it did not violate the community standards. Last year, US Democratic strategists received threatening tweets. He complained to Twitter, who said it did not violate rules against abusive behavior. A man later sent pipe bombs to politicians, and then, at that stage, Twitter said its earlier assessment was wrong. The actress who accused James Franco of sexual misconduct was also repeatedly harassed on Instagram. She made a report to FBI and said that Instagram ignored almost all of her complaints. Tech companies have admitted that they are unable to deal with some of these problems. So we need a solution. The amendments to POHA today give power to the people so that the man on the street can take back the truth and find a way to reclaim his dignity. We will seek to simplify the process to make it easier for the man in the street to get recourse, to get redress. Make clear what remedies he can get. Enable him to tackle falsehoods and harassments once they are published. Enable him to put out the truth, to counter falsehoods that may affect his livelihood, or in the case of a company, its business. So first, let me take members back to our first attempt back in 2014 to deal with online harassment holistically, when this piece of legislation was first enacted. This, members will recall, was the first piece of legislation dedicated to protecting victims of harassment, both offline and online. It laid down clear norms as to what constitutes unacceptable social behavior. The presence of this framework encouraged victims to come forward to seek help, to seek redress. To date, more than 3,000 magistrates' complaints have been filed under the Act. Over 1,700 prosecutions have been brought, about 900 convictions have been obtained, 500 applications for protection orders under this Act, and of which over 200 such orders were granted. These numbers demonstrate how important POHA has been as an avenue of relief to victims of harassment. And in introducing their revisions today, we have taken keen interest in feedback on POHA from at least these three groups. First, the courts. Second, the civil society groups. And finally, from the victims of harassment themselves. Let me sketch out the feedback that we've obtained, given to us by these three groups, which have been instrumental in shaping the amendments behind this bill. First, the process of obtaining relief under this Act. It is clear to us that processes under POHA can be simplified further, made cheaper, and also faster. The current process of applying for an expedited protection order, or an EPO, and a protection order, or a PO, can be streamlined. The forms can be made simpler, and some victims have said they feel that the need of the assistance of lawyers to navigate the current process. Currently, to apply for a PO, it costs about $300 to $500. In contrast, there is a simpler and more inexpensive method to apply for a personal protection order or a PPO under the Women's Charter. Those victims who choose instead to file a magistrate's complaint, there are some difficulties. First, the outcome of the complaint often turns on the conclusion of police investigations. Victims don't know when these investigations might conclude. And a victim who has filed a complaint with the magistrate does not have the benefit of protections afforded by a PO. If a PO is necessary, the victim has to separately apply for one in the civil courts. We can simplify the procedure so that a victim does not have to provide evidence of his or her harassment more than once. We can also ensure that we prevent the duplication, because reliving the experience only causes further mental anguish for the victim. Second, feedback received from the courts is that the courts should also be given more powers when making orders. In particular, the scope of the POs should be widened. It should cover related persons of the victims, as harassers often target persons close to the victim in order to get to the victim. The courts should be able to order offenders to be sent for psychiatric assessment and treatments where appropriate, as there are cases where mental illnesses may well be the root of the offender's behavior. Third, it was suggested that POs should also be given more bite. At present, a breach of a PO is not arrestable. This perceived lack of severity might be another factor which deters victims from coming forward and applying for POs. Further, our attention was also drawn to a specific group of victims, victims of intimate partner violence. These are often victims in a romantic relationship. They may be dating or married. If unmarried, they do not qualify for protection under the Women's Charter, which only protects victims of family violence. Some might assume that it might be easier for an unmarried victim to break off the abusive relationship. However, the psyche of an abused partner is sometimes the same, whether married or unmarried. The intimacy of the relationship allows the abuser to create a psychological hold over the victim and makes it difficult for the victim to break free. Research shows that romantic love can sometimes be like an addiction. A PAVE study in 2012, PAVE in Singapore, showed 1 in 3 unmarried persons between the ages of 15 and 34 were found to be in an abusive relationship. Of these, 2/3 had their first abusive relationship in their teens. On average, for 20% of those who were abused by their spouses or were themselves abusers, the abuse started when they were first dating. Let me highlight the case of Madam A. Madam A dated a man for 5 years. They had 5 children. Dating violence started in the first year of their relationship. The man began by shouting vulgarities at her. It escalated to physical violence. He hit, kicked, slammed her face on the floor, threatened her with a knife. And all of this in front of the children. He threatened to kill himself, all the children, and abuse the children. He would follow Madam A everywhere, track her whereabouts via calls, texts, GPS, and when Madam A decided to seek help, she could not apply for a PPO under the Women's Charter as she was unmarried. Her first child, who did not carry the man's name on her birth certificate, was in the same position. She could only apply for PPOs for the other 4 children. Madam A and her children had to go to a crisis shelter where they are living now. The man is in a new relationship. There are other such cases, and I'm sure members themselves will be familiar with their own experiences. We need to find a way for people in intimate relationships who are the subject of serious abuse to get POs more easily. PAVE, in particular, highlighted this strongly to us and has advised the government on how best to deal with the situation. As a result, we amended the Penal Code yesterday, and we are proposing amendments to POHA today to further strengthen the recourse. We have carefully considered the feedback, some of which I've sketched out, from our stakeholders, alongside the need for greater regulation. We will improve the process of obtaining reliefs from the courts. Let me start with that in the bill. The bill has a new Part A, which will establish the Protection from Harassment Court, or PHC. The PHC will be dedicated to dealing with harassment matters, whether online or offline, and will have oversight of all criminal and civil cases under the Act. It will be cited in the state courts and will have the jurisdiction of a district court. Judges will be specially trained to deal with harassment matters. volunteers will be available on hand to help victims navigate the court process. In egregious cases, it may not suffice to grant the victim of a civil remedy in a form of PO. The law may need to deal with the offender, even if the victim has not already gone to the police. So, in the bill, there is a clause 18, which imposes a duty on a judge granting the EPO to consider whether a criminal investigation is warranted. So the court has a proactive duty to look at facts, circumstances, in the course of granting the EPO. If it is, the judge must refer the matter to the police. The intention is for serious cases of hurt or harassment which come to the court to be referred to the police. This will ensure that the state can intervene and intervene at an earlier stage to reduce the risk of further or greater hurt to the victim. In addition, we are taking measures to help victims to meet the burden of proof. Clauses 16.1 and 17.1 provide that if the respondent has been convicted of a hurt offence under the Penal Code or a POHA offence, the requirement to show that the respondent has contravened POHA will be deemed satisfied. In other words, the victim will not have to prove his or her case more than once. In terms of streamlining procedures and expediting timelines, we have worked with the state courts to do so that the process of applying for a PO under POHA will, as far as possible, be aligned to that under the Women's Charter. The victim will also be able to file an application for a PO using a simplified form at the PHC or online. Relief will also be quicker and more permanent. Clause 17 will ensure that the EPOs will be in place until conclusion of proceedings unless they are successfully challenged. The victim will no longer have to renew the EPOs every 28 days. The hearings will also be conducted more quickly. The PHC will aim to conduct hearings for EPOs within 48 to 72 hours of application, and where there's an element of violence involved, the PHC will try to conduct hearings for EPOs within 24 hours of the application. The PHC will aim to conduct hearings for final POs within 4 weeks of the application. The timelines, of course, will be subject to practical constraints, such as, for example, if the application is filed over the weekend, the courts may only be able to hear it on the next working day. Applicants should, of course, always seek police intervention if they are in immediate physical danger. Finally, should the court decide to stay proceedings for a PO under the new Section 13A pending a criminal investigation, it may take longer for a PO to be granted. However, in that situation, an EPO will be in place until the PO is granted. We hope that these measures will relieve some of the anxieties that an applicant faces when invoking the court process and encourage those in need to come forward. Next, in terms of enhancing the protection for harassment victims and also related persons, we will enhance the protection for this category of persons, expand the scope of POs and the powers available to the court when granting the PO. Let me explain. First, Clause 16.1 widens the ambit of POs to deal specifically with the situation where an offender may publish a harassing communication which is then shared by others. A PO can now be made to prevent the publication of communications which are not just identical but also substantially similar to the offending communication. In addition, Clause 16.2 clarifies that Internet intermediaries can be ordered to disable access to an offending communication published on their platform. This is to try to stamp down on harassing communications going viral or spreading even further. Second, Clause 16.2 extends the scope of POs to protect related persons of the victim. This will ensure that individuals, such as Madam A in my example, will be able to obtain POs for herself and her children, rather than to live with the abuse and to worry about potential harassment or abuse to her children. Third, we have acted on feedback that the courts should be empowered to proactively intervene in cases where the harasser's conduct may not cross the threshold of criminal or dangerous conduct, but where the facts demonstrate that the harasser is mentally ill. Clause 19 empowers the court to order the respondent to undergo a psychiatric assessment after it grants a PO and undergo psychiatric treatment if certain criteria are fulfilled. The respondent must have, and the criteria are, first, the respondent must have psychiatric conditions susceptible to treatment, capable of being treated. The respondent must be suitable for treatment, and the psychiatric condition must have contributed to the contravention that formed the basis for the PO, having a nexus with the conduct complained of. The criteria and nature of the treatment will largely mirror the treatment regime under the Criminal Procedure Code with appropriate safeguards. Failure to comply with the orders will be punishable as contempt of court. Two further amendments in Clause 16(1)(a) clarify the law. POs can be obtained against entities who commit contraventions under the Act. The common law principles of attribution will apply. This will address cases that have already been brought before our courts, for example, where wayward companies might have crossed the threshold of lawful debt collection into criminal behavior, such as intentional harassment or violence, in the context of conducting their lawful activity. So harassing, intentional harassing, sometimes violence in the context of carrying out their debt collection. Companies may have sent different runners to harass a victim. Victims can now obtain a single PO against the company, and they do not have to bring each runner who conduct each of these harassment acts to court each time. Domestic exclusion orders are available under the Act, and these orders, which are also available under the Women's Charter, will allow victims to exclude a harasser from their shared residence. This is so even if the harasser has a proprietary interest in the property. We are also taking measures to strengthen the recourse available to victims and increase the deterrence factor of the remedies available under the Act. First, clauses 4 to 10 and 13 clarify that entities can be liable for contraventions under the Act. They can be prosecuted or sued for damages, and the common law principles of attribution will apply. This will discourage entities from allowing their employees to harass customers. Second, this House heard yesterday about amendments to Penal Code to double penalties for offences committed against vulnerable persons. Under the proposed POHA amendments, Clause 10 provides that penalties for POHA offences against vulnerable persons, be they adults or children, will likewise be doubled. Third, we spoke earlier about the pressing need to protect victims of intimate partner violence. The government has amended the Penal Code to provide for enhanced penalties for specific offences committed against intimate partners. In a similar vein, Clause 11 of this bill doubles the penalty if a POHA offence is committed against an intimate partner. We are also taking steps to ensure that a harasser who re-offends is also dealt with severely. At present, as I mentioned earlier, breach of a PO under POHA is not an arrestable offence. This is in contrast with the position under the Women's Charter. In response to concerns that POs issued under the Act are perceived as ineffective, we propose to amend the law. Clause 22 provides that if a harasser breaches a PO, this will be arrestable in prescribed circumstances, such as where hurt is caused or where the harassing conduct persists despite the issuance of a PO. In addition, Clause 9b provides that if a harasser breaches a PO more than once, he will be liable on subsequent conviction to twice the maximum punishment prescribed. This also brings the Act in line with the Women's Charter. I turn now to online harassment. I spoke earlier about the scourge of technology when not handled properly. I now would like to turn to amendments that have been targeted towards online behavior and harassment. First, on doxing. To understand the basis of the doxing amendments, let me first highlight a case that might fall through the cracks today. A Singaporean girl, whom I shall not name, was in the middle of her O-levels. She discovered edited photographs of herself on a Tumblr blog with pornographic content. She started receiving unsolicited messages on her social media platforms, and one day she noticed a man following her home. Her former best friend, it turned out, had emailed her full name, photos, address, and name of the school and tuition centers that she attended to over 60 porn blogs. With this knowledge, she retreated from her social interactions, afraid to even leave home. This young girl was a victim of harassment. However, the email sent by her friend to the porn blogs, despite its malicious intent, may not have been caught by existing POHA provisions, which require communications to be threatening, abusive, or insulting in themselves. The doxing amendments are an extension of the existing provisions on harassment and seek to deal with this lacuna in the law today. Clauses 4a and 6d introduce the offence of doxing. For this offence, the intention or knowledge of the publisher is key. Doxing will be made out if the person published identity information of another person, intending to cause harassment, alarm, or distress, intending to cause the victim to fear that unlawful violence will be used against him or another person, or to facilitate unlawful violence against the person, or knowing or having reasonable cause to believe that a publication is likely to cause the victim to fear that unlawful violence will be used against him or another person, or to facilitate unlawful violence against the victim. Identity information is defined as information that, on its own or with other information, identifies or purports to identify the victim. This includes photographs, contact details, address, and place of employment. The new offence will not affect most people who continue to engage constructively on the internet. It does not stop them from identifying the perpetrators of crime, including traffic offences or POHA offences, or indeed from posting videos of public disputes to give a factual account of an incident. On the other hand, publishing someone's contact details to netizens intending to harass or alarm that person, or intending that other netizens use the information to harass or hurt the person, is unacceptable. Publishing photographs and contact details of a girl, intending that others use those details to harass her, is likewise unacceptable. There have been concerns raised that the new doxing provisions could be too broad. These similar concerns were raised about the existing harassment provisions back in 2014. Harassment is heavily fact-specific, and doxing is a subset of that. It is no different. The law today, in fact, with these amendments, adds clarity. Doxing is currently prosecuted through a mix of provisions arising in different pieces of legislation. Courts will now be able to develop a body of jurisprudence on when the offence is made out, and furthermore, existing case law on when intent is made out in the circumstances can be relied upon. Other concerns have also been raised about whether the new provisions can deal with anonymous posters. Let me deal with that. Anonymity is not a new issue under the Act. Minister Shanmugam, when he spoke on this bill in 2014, addressed this. Even if the respondent or publisher is anonymous, he may be identified by an internet location address, website, or other unique identifiers as the court may order. In addition, POs are binding even if the person behind the account may not be identified. The POs can be served on multiple accounts as well. As with the other victims of harassment, such as cyberbullying and intimate partner violence, a victim of doxing will be able to avail himself of the streamlined processes and expedited timelines as well. The court may order that the offending communication be taken down by the offender and persons who have shared the original post or substantially similar posts. Where appropriate, the court may also order that an internet intermediary disable access to the offending posts. And finally, when an EPO involving online doxing is involved, the court will aim to hear the application within 24 hours. Let me now turn to online falsehoods. First, in terms of setting the context. Aside from doxing, the bill also enhances existing measures available to address the spread of falsehoods by repealing and reenacting the falsehoods regime. The falsehoods regime under POHA aims to help individuals to give recourse and redress against the effects of falsehoods, whilst at the same time striking the balance with the right of people to hold their own opinion and debate matters of interest. Broadly, POHA categorizes the remedies available by types of orders which are available, split into 5 categories. Section 15 deals with the final orders which can be given in cases of falsehoods, and Section 16 deals, amongst others, with interim orders for the same. This is similar to the approach taken in Section 12, which makes a PO available against both persons, entities, and intermediaries. In contrast, the Protection from Online Falsehoods and Manipulation Bill has distinct parts dealing with individuals versus corporate entities, and these are found in Parts 3 and Parts 4 of that bill. For the avoidance of doubt, the falsehoods regime under Section 15 and 16 of POHA and Clause 20 of the bill deals with false statements of fact. This includes misleading statements, but does not cover criticisms, opinion, satire, or parody. Let me make this clear. First, a statement that omits material facts is misleading. If the statement would have been considered by a reasonable person to be misleading by reason of such an omission. If, for example, A says that B is dishonest, that is a statement of opinion and not a false statement of fact. However, if A goes on to say that B was convicted by a court of cheating, then this is a false statement of fact if B was never convicted of such an offence. This is also false if B was subsequently acquitted on appeal.
Order. Mr. Vivin, would you like to move?
Mr. Speaker, sir, may I seek your consent and the general assent of members present to move that the proceedings on the item under the discussion be exempted from the provision of Standing Orders number 48, bracket 8, to remove the time limit in respect of SMS Edwin Tong's speech.
I give my consent. Does the Leader of the House have the general assent of the honourable members present to so move? Mr. Vivin, please proceed.
Mr. Speaker, I beg to move that the proceedings on the item under discussion be exempted from the provisions of Standing Order number 48, bracket 8, close brackets, in respect of SMS Edwin Tong's speech.
The question is, as moved by Minister Vivin, as many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. SMS Edwin, please proceed.
Thank you, Mr. Speaker. Going back to my example, the statement is also false if B was subsequently acquitted on appeal, because the statement conveys a false meaning by reason of its omission of B's subsequent acquittal. Once a false statement about a subject is established, Clause 20 sets out 5 orders that may be available to address it. Interim relief will be available for all orders save the General Correction Order. This was necessary given the speed at which online falsehoods can now spread. Interim relief can be obtained ex parte in the case of interim stop publication and interim notification orders, both of which are targeted at individuals or entities which publish falsehoods. In the case of interim disabling orders and targeted interim notification orders, which are directed at Internet intermediaries, notice of the application first has to be served on the intermediary. This is because the Internet intermediary is not directly responsible for the falsehood and should be given a chance to explain its position in court, should it wish to contest the application. Let me explain each order in turn, and start by saying that all of the orders, save the General Correction Order, are already available under the Act today. As is the case under the current Act, the Court will not make any of these orders unless satisfied, amongst other things, that 1. The statement being complained of is false, and 2. It is just and equitable in the circumstances to make the order being sought. The test of when it is just and equitable to grant a Section 15 order has been set out by our courts in case law. It is a flexible one, taking into account various factors, including but not limited to the nature of the statement, the seriousness of the allegation made, the degree to which the statement has been publicized, whether the subject of the false statement has the means to publicize his or her own version of the truth. A stop publication order requires a person or entity not to publish a false statement or any substantially similar statement. It is already available today, as I mentioned. The orders have been amended to include substantially similar statements. This ensures that publishers cannot game the system by simply amending the statement slightly, but such that it is still false. As with the present regime, stop publication orders can be taken out against multiple individuals or entities, and the applicants need not take out separate applications against multiple persons. Anyone who publishes the false statement or a substantially similar statement is bound upon service unless the court has dispensed with service. This deals with a situation where an anonymous user may use different online accounts to publish the same false statement. This will be covered by the order, regardless of which account is used. Next, on correction orders. These are available today, but fleshed out in the amendment bill. I spoke earlier about how falsehoods travel faster, deeper, and more broadly than truth, and that repeated exposure to false statements on social media make them more believable. Correction orders seek to address this problem. There may be cases where it is not enough to order a respondent to stop publishing a falsehood, and it may be necessary to go beyond that to require the respondent person or entity to put the truth out there. The respondent in such a case will be required to publish a notice online or in a printed publication stating that the statement in question has been found to be false and correcting the false statement. The respondent will also be required to make the notice available to persons or specified description of persons as determined by the court. Next, on disabling orders, which are available today, they can be made to require an internet intermediary to disable access to a material containing a false statement on the internet intermediary's platform, so that it is no longer available to viewers. Next, targeted correction orders, which are also available today. They are in like vein to correction orders, but can be made against an internet intermediary. It requires an internet intermediary to distribute a correction of the false statement to viewers of a false statement on the internet intermediary's platform. So it carries the corrections on the platforms. Again, the purpose of this is to ensure that where the false statement has been published by way of the internet intermediary service, the truth is made accessible to viewers of the false statement. Finally, the general correction orders, which are new. Let me describe them. They can be made where the court is satisfied that serious harm to the reputation of the subject, whether professional or otherwise, has been caused or is likely to be caused. Unlike the other orders, they operate against a prescribed third party who has not been responsible for the publication of the false statement. This third party, as an example, could be news outlets, broadcasters, or internet intermediaries. The prescribed third party can be required to publish a notice stating that the statement in question has been found to be false, as well as a correction of that false statement. The rationale of this? Well, the ubiquity of technology nowadays means that falsehoods may spread across different platforms. It may start on one, it may carry through to one or several others. It might be difficult to identify who has been exposed to a falsehood. As mainstream purveyors of information, prescribed third parties have a sufficiently wide reach to help to correct the viral falsehoods, which are particularly serious or persistent. What are some of the safeguards? As this order imposes obligations on third parties, interim relief will not be available. The third party should be allowed to fully contest the claim if it wishes to, before an order is granted. However, a victim can still rely on other forms of interim relief to stop or stem the spread of falsehoods, such as the disabling order or the interim stop publication order. In terms of the relevant procedure for these orders, the same streamlined process I mentioned and also expedited timelines will apply. The PHC will aim to conduct hearings for the interim orders within 48 to 72 hours of application. And given the speed at which online publications can go viral, the PHC will aim to hear the application for an interim order within 24 hours of application, if the false statement has been published online, subject to any other requirements to give notice. The interim order will remain in place until it expires or has been cancelled. As with POs, the PHC will aim to hear applications for final Section 15 orders within 4 weeks of the application. Finally, non-compliance with the orders will be punishable with contempt. It's similar to the current regime, and contempt only if non-compliance is intentional. For those who wish to appeal against an order under Section 15, they will still need to seek leave under Section 21 of the Supreme Court of Judicature Act. In light of the decision by the Court of Appeal in AG versus Ting Chun Ming, which ruled that only individual persons have recourse under Section 15, Clause 20 of the bill states that both individuals and entities can apply for remedies under Section 15. As with the other remedies under POHA, the government will not have recourse under Section 15. Government will have to rely on the POFMA, POFMB, well, currently the bill. Likewise, Section 15 orders can be made against both individual persons and corporate entities, but not the government. Allowing entities to seek relief will ensure that the companies and their staff do not suffer, lose their livelihoods as a result of falsehoods. Mr. Speaker, sir, after 5 years, we have introduced a significant number of amendments to keep pace with changes in technology and to be responsive to feedback as to the ease with which applications can be brought and relief granted. The bill builds upon an existing ecosystem to deal with harassment and to offer victims recourse and redress. It is equally integral to this ecosystem that there are many volunteers, psychiatric institutions, the police, the news agencies, schools, and many others. They are all part of this ecosystem, and we are grateful for the efforts in highlighting harassment cases, issues, broadcasting the remedies available, and also assisting with the victims. Finally, I must underline the fact that the levers that we have devised under this Act are designed to be responsive in nature. They offer protection, recourse, and redress. At the end of the day, harassment is a social problem which requires a concerted social response. We all bear a responsibility for ensuring that harassment is not perpetrated or escalated. This is the surest way to provide victims with protection. We should not tolerate any harassment or violence, least of all those which occur in an intimate partner or family setting. Mr. Speaker, sir, I beg to move.